go.
Hello. Today we are going to be critically discussing how legal subjectivity and Byron's vulnerability theory operate in the context of genital cutting, female genital cutting, FGC, and male circumcision, MC.
We're going to start by defining each concept. Anna Greer has the most accepted definition in her 2011 paper of the liberal legal subject, in which she defined it as including theoretically genderless. We will discuss how the issue of gender harms the social construct of the liberal legal person.
Vulnerability theory is based on the idea that humans are universally and constantly vulnerable, and it's one's access to resources that affects their resilience. Feynman believes that the state should be more responsive in order to address the differences in vulnerability.
FGC is the cutting of the whole or any part of the labia minora, labia majora, or clitoris. FGC is usually performed for social acceptance, religious beliefs, enhancing male sexual pleasure, or to protect a woman's virginity. A common misconception about FGC is that it improves female hygiene. There's no evidence for this claim.
MC is the surgical removal of the foreskin. It is most commonly practiced amongst Jewish and Islamic communities.
Legal subjectivity and vulnerability are intertwined with genital cutting, as the debate regarding genital cutting incorporates the issue of gender. A person's gender affects their ability to consent to genital cutting, which proves the law is not genderless. We will analyse why gender impacts the legal capacity to consent to genital cutting, how certain individuals and communities are more vulnerable to the harm of FGC, and if the law regarding genital cutting should be reformed.
In recent history, surgeons in the US and Europe used FGC to prevent female masturbation with the belief it would cure a range of conditions such as insanity, hypersexuality, hysteria, fits, and death. MC was also carried out for similar reasons, which raises the question of why are the practices received so differently in modern society. This ties in with the liberal legal subject, which in theory is genderless, however in practice is gendered in that males are afforded more agency than females.
FGC was outlawed in the Prohibition of Female Circumcision Act of 1985, and the Female Genital Mutilation Act of 2003 extended the sentence from the 1985 Act from 5 years to 14 years of imprisonment. Therefore, it could be argued that by extending the sentence, UK law is further entrenching the difference in agency conferred to males and females, as FGC carries a heavier sentence. Even though it's estimated that 137,000 females in England and Wales have undergone FGC, the first person was only convicted in March of 2014. Therefore, has UK law had a significant impact on the agency of women in practice? This will be explained in the next slide.
Legal subjectivity links with FGC as the issue is founded upon gender. Sarat and Kearns explain how legal subjectivity places emphasis on political, cultural, and moral values, all of which will be discussed in turn when analysing genital cutting.
Politically, the law takes a stance to combat FGC. However, Parliament and the judiciary have historically not been genderless. When the Prohibition of Female Circumcision Act was introduced in 1985, just 23 out of 650 MPs were female. Dezenas explains how liberal legal subjects give authority to legislators, as Parliament is meant to act on behalf of the people, and ideally should reflect the composition of society.
Moralist Spivak portrays FGC legislation as white men saving brown women from brown men. This belief has negative connotations, as women appear as narratives of law, but not lawmakers, even though women are essential and are at the focal point of FGC.
Culturally, the law overlooks the issue that some women want to consent to FGC, as there is a blanket ban on FGC. David Wilshire argued in the House of Commons that the bill should take into account cultural and ritual reasons, as the practice enables somebody to be more respectful to their god or guru. Shavishi states that even though male circumcision and FGC are closely parallel, FGC is predominantly used to curtail a woman's sexuality, whereas MC is mainly performed on religious grounds.
In UK legislation, girl and women are used interchangeably, showing the law expands beyond issues of child protection. Therefore, the UK law is seeking to protect girls and women from the vulnerability of the barbaric practices, as stated by Anne Cloud MP, but doesn't reflect the difference in capacity to make decisions between female children and female adults.
In contrast, the US law on the federal prohibition of the FGM Act 1985 criminalises practicing FGM on people under the age of 18. It can be argued, therefore, that the US approach confers more agency than the UK, since it allows women to make a decision when they are over the age of 18.
However, we must be careful when praising the US law because, as seen in United States and Jumana Nagawala, Judge Bernard Friedman held that the statute went beyond federal powers, since criminal legislation can only be adopted by states, therefore rendering it ineffective. Nevertheless, it is a step in the right direction in balancing female agency and protecting vulnerability.
Feynman's vulnerability theory is also intertwined with MC. Significant benefits of MC regarding health, medical, and cosmetic benefits explain why MC is an ingrained part of diverse human cultures all around the world, most notably in hot, arid environments. It is also now the most common surgical procedure in the world for males, to the extent that WHO and UNAIDS currently support and encourage voluntary medical MC in HIV-1 epidemic settings. The fact that MC is most prevalent in hot, arid environments, for example in Africa, shows how one's access to resources causes people's vulnerability to differ. There is a lack of access to condoms and sexual education, resulting in them being more at risk of contracting AIDS. This has consequently led to a 91.6% MC rate in Ghana, compared to a 20.7% rate in the UK, in which access to healthcare and education is better, thus highlighting the disparity in resilience through access to resources.
The cultural and moral values are at the forefront of the debate surrounding MC. There is a contrast in society's approaches to MC and FGC. This is clear because of the Office of the High Commissioner for Human Rights identifies FGC as a harmful practice affecting the health of women and children, but does not include male circumcision. The majority of boys that are circumcised at a very young age, and therefore lack any form of ability to provide consent over their bodies. This ties with societal values, as any form of pain and suffering experienced by a boy is a positive one because it makes them more manly.
The law surrounding genital cutting has been subject to much scrutiny. The Welsh Government Strategic FGC Leadership Group have established an action plan, including developing legislation to place a statutory duty to produce a range of local strategies focused on education. However, for MC, the UK should pay more regard to the issues raised by the British Medical Association regarding whether a child can consent to MC.
In conclusion, there is evidently an imbalance in agency between males and females in relation to genital cutting. To satisfy the liberal legal subject's definition of theoretically genderless, the law should take inspiration from US law on the prohibition of FGC and the BMA's comments on whether a child can consent to MC, to develop a legal framework allowing both males and females to consent to these procedures if they are over the age of 18. This strikes a balance between protecting people from vulnerability and also promoting agency in males and females. Thank you for taking the time to listen to our presentation.